it's Ron again. I keep promising you that we're going to talk about responding to that complaint that you've been served with and finding reasons not to get there just yet. These are good reasons, though. That's the value proposition, after all, here, because I want to make sure you consider things that you won't necessarily find in a do it yourself guide. So, last episode or last lesson, we talked about what happens at this juncture. What are your options? Not just your procedural options, but what should your lawyer be thinking about and talking to you about at this moment in the litigation? There's one more thing that is really critical to address at this point, and that is, if you haven't done it already, which you probably should have, but chances are it's okay if you do it now. If there's any chance that you have insurance that can cover your expenses and your defense, and ideally any liability that you might incur for this claim, you must put your insurance company on notice immediately. If you are a business and you have a commercial general liability policy, which you should, it will have provisions in it for giving notice to the insurance company when you get sued. You must pay attention to this. You must do what it says. It's always the case that you need to give that advice or put on notice or give notice to, I guess that would be the English word, the English phrase, to your insurance company as soon as you can. So sometimes you'll see the words as soon as practicable, which is a very weird way of saying as soon as possible, but it is a language that sort of does find itself into law speak. The basic idea is you need to make sure that nothing happens in the lawsuit that could prejudice the ability of the insurance company to defend you, and ideally let's be very clear about something. Insurance companies have a legal and, in fact, a fiduciary obligation to people who are insured to put their interests, the insured's interests, ahead of their own financial interests. That duty is violated every single day. Insurance companies are businesses, and they're mainly in the business of denying claims. Now, very, very often, but not often enough, insurance companies will be conscientious enough to not deny claims where they shouldn't, but they also will very frequently deny claims. Sometimes they will accept the defense of the claim upon what's called on a reservation of rights. In other words, they'll say, we've got some questions about whether or not this is covered by your policy, but we can't answer them at this juncture. Therefore, we will provide the defense that our policy and the state law require us to provide. But that doesn't mean that we're necessarily going to cover your liability. Your lawyer should talk to you about what happens if you get a reservation of rights. Depending on the policy and depending on the business and the situation, you may have the ability to continue working with the lawyer of your choice, who will then be reimbursed by the insurance company. Maybe not at his or her usual rate, but usually it's manageable. In many cases, however, the insurance company, and this, again, will depend on the policy to a large extent, the insurance company will provide its own defense. When that happens, you should still be talking to your own lawyer, probably, at least until you are satisfied with your lawyer's advice that you're getting the coverage and the defense that you're entitled to. If there is a reservation of rights, may be in a position where you ought to object to their reservation of rights in order to preserve your rights as against their reservation of rights. This isn't meant to be comprehensible or necessarily logical. I mean, there is a kind of internal logic here, but I'll tell you where it can make a very big difference. Most insurance policies will provide a period of time during which you must give notice. Sometimes it's as soon as practicable, or sometimes it's within 30 days, within 10 days, within 5 days, depends on the policy. What if you give late notice? In some states, such as New York, at least when I did this kind of work, if you give late notice in New York as set up as defined by the contract says 20 days and you take 25 days, and it's a $10 billion liability, and defending it is going to cost you $5 million in legal fees, which should be covered. If notice is late, there's a very good chance that you're out of luck because you have failed to fulfill a condition precedent to receiving your contractual defense and indemnification. New York, at least historically, maybe not so much now, but historically has been a very business-friendly jurisdiction. But business-friendly is a very vague term because if you're a business and you've been sued and you're having trouble getting coverage from your insurance company, that's also a business. Because insurance companies have historically had, in places such as New York law tends to be very insurer friendly. So even if it's just a little bit late, you could lose your right to the indemnification and defense that you've been paying for, maybe through the nose, for a very long time. On the other hand, the same scenario, if it were to happen on the side of the river that I'm on now in New Jersey, the court will require the insurer to demonstrate that the late notice caused it prejudice. In other words, okay, he was late, you're right. So what? He was 5 days late. The answer isn't even due for another 30 days because you entered into a stipulation or accepted service. Nothing's happened. No evidence has been destroyed. No motions have been decided. You're not getting out of this very substantial obligation that you have without showing us that you, insurance company, you've lost some bargain for material benefit that comes with timely notice. That doesn't mean notice doesn't matter. You've got to give notice as soon as you possibly can. If you're a private individual, or just an individual, because I think most individuals are private. Of course, I'm Ron Coleman. I'm a public individual. Everyone knows everything about me, but even I, legally speaking, I'm a private individual. You may have coverage. So chances are you don't have a commercial general liability policy, but you do have a homeowner's policy, which may or may not include a general liability umbrella. But either way, your homeowner's policy may protect you for many types of claims that are not related to your business, but might be related to liability against you for anything other than voluntary act. In other words, insurance policies will never indemnify you for intentional conduct and intentional wrongdoing. That would be against public policy, and it would be a really dumb business model. Intentional claims are never covered. However, claims for negligence should be covered if you've got any kind of liability policy. That is, to a large extent, why you sometimes have these reservations of rights, because the policy doesn't cover you for intentional acts, but the claims against you include both intentional acts and negligence, or the claims against you have been pled in the alternative, such that the court could find you liable not for intentional conduct, but for negligent conduct. Whatever the case may be, you need to make sure that you give notice on time, and if you need the help of a lawyer experienced in commercial litigation to guide you through that process, then you should probably contact one. You certainly shouldn't rely on what I say in this video as legal advice, right? All right. So make sure you give notice. Make sure you don't destroy, delete, start settlement negotiations, anything. Even if you're going to talk to a lawyer, you don't need his permission. Immediately send a copy of the lawsuit to your broker or to your insurer, depending on the relationship and what the contract provides. Get a confirmation, keep a record of your having sent it, see how that goes. You may very well be covered, but if you're not covered, let it not be because you blew it on the notice side. Talk to you next week.